some time ago. The defendant already received probation in May. My agreement, my representation had ended at that point. Unfortunately, Mr. Boyd still thinks I am his attorney. So just to be clear to everyone, I've sent him a copy of this motion and I'm asking the court to sign.
Okay, we'll go on the record. The court is calling 2023 CR 3281, State of Texas versus Eugene Boyd. Can I have parties announced for the record for the state?
Hank Wilkins for the state, Your Honor.
For the defense?
Melissa Christian.
Are you Mr. Boyd?
Yes, ma'am.
Yeah.
All right, your attorney has filed a motion to withdraw. Are you aware that your attorney wishes to withdraw?
Yes, ma'am.
All right, the reason she's withdrawing is because her representation has concluded. Was this an appointed case?
It was, Your Honor.
All right. So once the plea agreement was entered and you accepted the plea bargain agreement, her representation at that point ended. So she is filing a motion to withdraw so that on the record, her representation can be ended. Do you understand?
Yes, ma'am.
All right, your motion to withdraw is granted.
Thank you, Judge.
You're welcome. Yes, you may be excused. Now, Mr. Boyd,
Yes, ma'am.
we have an issue. Do you know what that issue is? And we can go off the record. The issue is you're supposed to go to, first I sent you to felony drug court. And you didn't want to do that.
It's not that.
I know. Here's the thing. I've told you this time and time again, and I don't know how many times I have to tell you this.
But this.
Nope, listen.
Okay.
I am in charge of setting conditions of probation, not the state, not your attorney. When you signed your agreement with the parties, your plea bargain agreement, and I go over the pleas in great detail so people can understand. This right here, I let people know that this is outside the agreement. These are recommendations from the state and the court does not have to follow that. Do you understand? And your answer was yes, because if your answer would have been no, I would have said, all right, you all need to go back and confer. Let me tell you what this note says, and it's in all caps. The parties are not allowed to make binding agreements regarding the length of community supervision or the terms and conditions of community supervision, which are totally dependent upon the court's discretion. The following recommendations do not constitute part of the formal plea agreement. However, the state, both parties, make the following non-binding recommendations. So I know you keep saying, I'm not supposed to be at safety. I'm not supposed to be in felony drug court. Guess what? You are, because I ordered it. And there is no agreement that could have been made between your attorney or the state saying these are the only conditions he will accept. So let me just tell you what's going to go down. I'm not having another compliance with you. You're either signing to go to safety or a motion to revoke is going to be in it. The end. Do you understand?
Yes, ma'am.
You have been back before me numerous times with me explaining to you why you are being recommended for different things. I don't send anybody to felony drug court unless they have a drug problem. You have a drug problem. I don't send anybody to safety or SATF if they don't have a drug problem. You have a drug problem. And for some reason, you don't want to acknowledge it. So maybe you want to go to prison. If you want to go to prison and do your time, you're looking at 5 years in prison, potentially. So if you would like to do your time, then stop wasting everybody else's time. I'm not referring you back to felony drug court. I referred you there twice. And I received a note said, you were rejected. Client was offered felony drug court for the second time and refused. So you're not going back to felony drug court. So you're either going to SATF or a motion to revoke will be filed. So which do you prefer?
I'll go to Saturday.
You are signing that today. And if you do not sign it today, a motion to revoke will be filed and we will be hearing whether or not you should go to prison. Do you understand?
No,
Is there anything else you don't understand?
it's fine, ma'am.
All right. Thank you.
Thank you.
Oh, I'm sorry. I need to write in that thought. All right, Ernest Ramon. Yes. So what is happening here?
Well, yeah, I've spoken with him and he's perfectly capable of communicating to me in his own defense, and he understands the charges against him.
All right. So have you conferred with the state?
No,
All right. So you need to confer with the state. And this is family violence. So, Brittany, can you make sure that you all confer with him? All right. Just have a
this is
seat.
just on the issue of his confidence in Trump.
All right. But you said you've conferred with him and he understands everything. You just told me he's not incompetent.
Yes.
All right. So confer with the state.
That's my opinion.
All right. So confer with the state.
Okay.
Thank you.
Mr. White.
So did you have a chance to speak with any of the prosecutors to see what they do? Okay, awesome. And so right now, what's happening is the attorneys are conferring with the state to see if they can come to some sort of an agreement. If they can't come to an agreement, what will end up happening is, depending on where they fall on the docket, they may be set for a jury trial. Yes, if they can. Sometimes the issue is they don't have all the discovery. And I want to make sure that both the defense and the state have all the discovery they need and they're actually ready. So sometimes on cases, some of these are first settings, and the fact that this is the first time they've been to court because the case was recently indicted. So what I like to do is get a chance for the defendant to know what's going on in their case. And honestly, communication is key, because if you think about it, people, 9 times out of 10, people are charged with offenses. They don't know the process. They think, oh, I've been charged. We're taking care of the case today. And sometimes you can't, because everybody doesn't have their discovery. And discovery is just all the information about the case and any other extra things that the state may have or some third party may have. Yes. And so we'll set it for a discovery date. And so right now we're about to do a sentencing on Guadalupe Gutierrez. So in this case, they entered a plea bargaining agreement. He applied for deferred adjudication. And yes, so what ends up happening when they apply for probation, they come to the court and I make a decision off the PSI, and the PSI is really just a pre-sentence investigation report. And in it, it will tell you the person's criminal history. It will give you a recitation of the facts of the case again. It will have in it any type of statements from the complainant and any statements from the accused. It will say if the person has mental health issues, if they have drug issues, what their home life is. And so I'll base my decision off the PSI report and any other evidence that people submit to me. So in this case, their plea bargain agreement is a cap of 10 years, and the state is remaining silent on their application. So that means the state is not going to say, yes, I want this person to have deferred adjudication, or no. They're going to be silent. But even though they're silent, they are able to speak on fact issues. If they think someone is leaving a false impression with the court about a certain fact, or if they think somebody's being dishonest about a specific fact, then they can talk about that. But otherwise, they're silent. All right. Oh, that's from probation. Yes. And probation is, I don't want to say they're backlogged, but it takes a while because they have to make sure that the information they have in the PSI report is correct. You don't want to get a PSI report that say somebody was in prison for murder and then it turns out they were not. So they have to do all the research on that and make sure their reports are correct. Yes, they'll go see him or her. If they're at the jail, they'll go see them. If they are on bond, they will set up an appointment for them to come in, and the defendant can talk to them, or they can say, my attorney told me not to discuss this. When I had clients, depending on the charge, I would say, don't discuss it with them. So that's what we're about to do now. All right, who are the parties on Guadalupe Gutierrez? Sure.
Just have a brief moment just to read the case.
All right, so just give us a moment.
Okay,
So how's the weightlifting coming along?
it's on Judge August 8th.
I'm so excited. Okay, she's
Powerlifter.
a defense attorney, but she's also a power lifter. Oh, she makes us all feel like slugs. I watch her lift all the time.
And I so appreciate it.
No, I admire you. That is awesome.
So when I competed in June 2nd, that was a qualifier for this meet. And I made the ultimate
Mhm.
for this photo. And first, after that meet, I'm away already. Then when that spot opened up,
Yes, you're ready. You need to do it. Oh, my mom and I are going to send prayers.
thank you.
Yeah, I know you're going to do great. And you know what? The fact that you actually made it, that's awesome.
So
We'll have to do something. All right, and then sometimes I get these that are off docket. And basically off docket matters are attorneys just coming in. They want me to hear something that is not on the day's docket. And so what ends up happening with these cases, I put them at the end of the file because they're not on the docket so that I can handle the cases that are currently on docket. Let me see.
Angela Gonzalez. Ruben Ariano.
All right, Charles Gold.
I hear good.
Yes.
Good.
Good morning. How's it going? Yes. So on this case, have you had a chance to talk with the state?
Yeah, they just said to bring the complainant forward and that you want to talk with them.
Yes. All
And so
right,
I got them right here.
let's come forward.
Don't know when you come up here, sir.
And where is your client?
I didn't bring him. If you want to redo this, I'll do that later on. I didn't know.
Well, you want to have him by Zoom?
I didn't want to violate any.
No. You want your client by Zoom?
No, I was going to do it without his being here. I figured this was something that you just wanted to speak with him about.
All right. Well, what we can do is I can speak to him about it, but if you can have your client by Zoom and that won't violate the no contact, are you able to have him Zoom in?
I didn't tell him about this at all.
Oh, no. If you can see if he can Zoom in, because if I grant this, I want to give him instructions.
Understood.
Yes.
Understood.
Yes. If you want to call him and speak to Miss Ferguson, because she has the Zoom link. And
Okay.
state, are you going to be an objection?
We're not waving our arms and objecting. No.
Okay. All right. So just see if you can get him to Zoom in and we'll take it out.
Okay, have a seat back there, Mr. Kevin. I'll be right with you. Sorry about that.
Oh, no problem. No problem.
I don't need to stay here no more. I can go through this.
So this is his motion and that's what he wants me to hear.
Okay. You can have it. Right. So that's just, okay, we're ready, Judge.
Okay.
It's not.
All right, Diana, are you ready? All right, I'm going to need everyone to whisper. And Mr. Piker, if you can move your client down to the other end. Court is calling 2023 CR 1012, State of Texas versus Guadalupe Gutierrez. Can I have parties approach and announce for the record for the state?
Daniel, let's work with state check.
Defense?
Lorraine Efron for defendant, or ready, Judge?
And are you Mr. Gutierrez?
Yes, sir.
All right, you entered a plea of deadly conduct with a firearm as a third-degree felony. According to the plea bargain agreement, punishment is to be assessed at a cap of 10 years. The state is remaining silent on your application, and then there are no contact orders. Have both parties had a chance to review the PSI report, state?
Yes, sir.
Defense?
Yes.
Any objections to the PSI report, state?
No, Your Honor.
Defense?
No, Your Honor.
All right, the state is silent. Defense, do you have any witnesses?
Just, if I may, I have a couple of paycheck stubs or 3 paycheck stubs of my clients that I'd like to offer. And I had given the state an opportunity to review them. And then I have some photographs of my client with his daughter, if I may offer those to the court for your consideration.
Yes.
Judge states on.
All right.
I also have a letter from his boss, Judge. I need to find that.
Okay.
Oh gosh, I may. Where would he have sent it from? Okay. I'm looking for that letter from his boss, Judge. I
All right.
have read-
If there's no objection from the state, if you want to make a proffer what the letter says, I do believe he's employed.
Yes, Your Honor.
You can look at this as a
It
matter of
just,
public
it
record.
speaks to his, promptness as an employee, as a valuable employee, and as to him being consistently employed and being able to continue to be employed should the court grant this application. This speaks to how much the employer values him as an employee, Judge.
Okay. All right. Is there anything else?
Mr. Gutierrez, on his behalf, Judge, has had a lot of time to reflect during the pendency of this case. He has 3 children, including a daughter whose picture I showed you, his biological daughter. And he has recently reconnected with her and reestablished good communication with her mom and with her. And he feels extremely motivated now between the opportunity he has at work to do well and his relationship with his daughter being very positive. And he wants to be able to continue in that path and show the court that he can do better. I see the PSI recommends intensive outpatient. I think their focus is probably alcohol. And if the court were to deem any other conditions, he would absolutely comply with whatever conditions the court would deem appropriate. He has been on GPS for a considerable amount of time while this case was pending. I think maybe since
So it's been a year or 2 months.
a year and 2 months, he's been on GPS with no violations. And I think that speaks to his motivation to do better and his respect for the court orders and his ability to be a successful probationer. And I hope the court will take into account, that's a significant amount of time. He was on full GPS house arrest, and then that converted to partial, where he's been able to work, but no violations. And so we're hoping the court will give him an opportunity to show the court that he can be successful on probation.
All right, but here's my concern and what I don't understand. How old are you?
37.
You're 37. I don't understand going to a bar and people tell you to leave. And your answer to people telling you to leave is, I'm going back to my vehicle and I'm getting a gun and firing the gun. I don't understand that. So I don't know if he wants to be under oath to explain that to the court, but this is what I'm trying to wrap my head around. I don't understand why people's first answer to any situation is, let me go get my gun.
Well,
And I know people, I don't know, people seem to have a love affair with weapons. And if you want to have a love affair with the weapon, then you need to treat the weapon with respect, because the weapon can kill if it's in the wrong hands. And I'm just trying to figure out, there's an incident that happens. Somebody calls you out your name. Oh, let me go get my gun. I'll show you who I am. Somebody tells you to leave a bar because, I don't know, maybe you're intoxicated. Maybe there's some altercation. I don't understand why people don't leave.
I would say that the offense report and PSI reflect that he says he had 5 beers and 3 shots. So I would submit to the court that he was not thinking.
Yeah, I mean,
He
to
was-
me,
And I'm not saying that intoxication is a defense or mitigating at all. I'm just saying that, it causes a loss of impulse control. And
I mean, I understand what you're saying, counsel, but sometimes I think alcohol gives people courage to do what they otherwise wouldn't have done, as opposed to, oh, my inhibitions are released. Yeah. So I don't know if he wants to speak to the court or not, because I'll tell you, I'm leaning towards sending you to prison. I haven't heard anything that would suggest to me that I shouldn't send you to prison, because I don't know somebody who takes some shots. I realize you were intoxicated. I'm reading it, but people put you out of the bar. And it's on Mother's Day too.
It was 6 guys that took me out.
Yeah,
So
because you wouldn't leave. When people tell you to leave an establishment, just leave. So I don't understand why I should give him deferred adjudication when he went to a bar and, according to things he's saying, somebody tried to come on to his fiance. That's when you leave. And they told him to leave, and maybe they were very rough and pushing him out of the bar. I will give you that. They were rough. They bruise you up, maybe push you out of the bar. But that's where you leave and go home. Hopefully you were not driving with those tequila shots. And then, or if you don't want to leave and you stay in the parking lot, you call the police, but you don't tell people, well, I'm going to show you who I am. And then you go to your vehicle and get your gun. Did your fiance say any, did his fiance say, hey, what are you doing? This is crazy. Let's just go home.
I don't know if that's-
Okay.
The altercation at the bar wasn't good. I think that there were probably others there who also had weapons. Again, not to say that there's necessarily a defensive or mitigate, but maybe it's a little mitigating. It just turned out to be a very rough circumstance. I'm not making light of the offense because obviously it's serious. And I think that the PSI speaks to the alcohol being an issue and intensive outpatient. So I think if the court would give him some opportunity to address the alcohol and maybe perhaps anger management issues, maybe that would help to lessen his future risk to the
And I
community.
see that there are other people who had guns, because I see Eric Fields, who's one of the complainants, not the main complainant. He says, I just want my gun back.
Yeah.
This is Texas. We just want our gun back.
So, ma'am, I haven't been in trouble since 2005, and being at that
You want to
bar,
raise your right hand to be sworn in? Do you solemnly swear and affirm that the testimony you give will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand, state your name for the record.
Guadalupe Gutierrez,
Right. And let me just tell you, your statement about you haven't been in trouble since what time?
2005.
I haven't been in trouble since 1969, and I'm putting it at 1969 because I was potty trained by then. And I didn't pick up any criminal cases. I always tell people when they tell me, I haven't been in a gang, I don't do drugs, I haven't been in trouble. It's like, do you want a cookie for that? That's what you're supposed to do. So let's not start with, I haven't been in trouble since this date, because I'm looking at your criminal history and one of them is terroristic threat. And then criminal trespass. And is this criminal trespass with a weapon?
That was with a box cutter at my aunt's bar. I just left work.
Okay. And then the theft of a vehicle.
That was back in '04.
Yeah. And now we're back here.
Yes, ma'am.
And on the probation from 2013 on the criminal trespass with a weapon, your probation had to be extended. Then on the theft case, a motion to revoke was filed and you were sent to TDC. And now you have this that started as an aggravated assault with a deadly weapon and the state reduced it to a deadly conduct 3rd degree. So speak to me. Why should I give you deferred? I don't understand why I should.
Well, I mean, I'm not a good talker, but
That's okay.
Maybe not to say how it started, but
No,
I
go.
was trying to prove a point that since 2005, I haven't been in trouble, and all those years I was in the oil field for 15 years and I've never had my daughter. So now that I got my daughter, it's a blessing to me because I always wanted it. So now I have an opportunity to be a father and I don't want to mess that up.
I mean, but you have.
I understand.
I think the reunification, if you will, sort of took place after this offense. Is that correct? Meanwhile, you've been on probation with your daughter.
It's been good. It's just like I've been on the monitor and I can't blame nobody else but me. But it gets me kind of angry because I can't take my daughter out other than be with her in the living room.
Well, I don't know why you're angry about that. That's all on you.
That's what I just said.
If you would not go to a bar drinking to the point of intoxication and you're in your 30s, you're not a teenager who doesn't know better.
Yes.
I think that if the court would give him an opportunity for some form of treatment, I think he would welcome that and appreciate that opportunity.
I just don't think he's a good candidate for probation. I mean, shooting up a bar, and it wasn't.
It was outside in the parking lot.
Thank you. And State, I know you're silent.
Yes, Judge.
Is our applications for probation, for community supervision and deferred?
Yes.
I don't know if it makes a difference to the court. I don't think it necessarily does, but we can withdraw the deferred.
Now, see, this is what I'm reading, and this is my problem. I can understand people being angry and getting upset with people. I honestly don't ever understand people pulling a weapon, because I always taught if you're going to pull a gun on somebody, you need to know that you're to kill somebody, and don't pull a gun unless you're going to use it. That's what I was always taught. But what it says here in the police report that you stipulated to, I contacted Jason, who is the manager and point of contact for surveillance. Jason provided me with footage from one of the cameras. Jason said he was working on getting footage from the other cameras as well. The footage showed Guadalupe, that's you, being taken out of the bar. He walks to his car and pulls out a small handgun. Guadalupe pointed the gun in the air where 4 spent shell casings were found. Guadalupe and Melissa got into the vehicle and he pulls up to the curb. Eric can be seen in the corner near a white car. Guadalupe opens the car door and his hand extends out. Guadalupe then lowers his hand with the gun and points it toward Eric.
I never pointed the gun at anybody.
I mean, that's what they say is on the video. I mean, this is video. This is not.
And I showed her that when I saw the video, I pointed it.
Well, because it's surveillance, some parts of it are a little clearer than others, but as the car drives out, it's a little bit less clear because of the angle of the camera.
Okay. All right. Is there anything else from either side?
Nothing from the state, Judge.
No, Your Honor.
All right. How old is your daughter?
7.
Okay. All right, this is what the court is going to do. The court is going to find you guilty, sentence you to 3 years in the prison, give you credit for any time served. There's to be no contact with Eric Fields and Lefty's Draft House. Showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, and because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes.
All right, good luck to you. I did take into consideration that you have a child and that you want to be in her life and do better, but you're going to have to start making better decisions. And it's obvious that you can't drink alcohol at all. So no alcohol, you understand? All right, good luck to you. Who's here? Austin Anderson?
Hang on.